The certified letter arrived on a Tuesday morning in March, and I knew before opening it that Susan Patterson had found a new way to make my life hell. I stood on the porch of my cabin in the mountains outside Asheville, North Carolina, holding the envelope with the HOA's return address stamped in aggressive bold letters. The morning mist still clung to the pines surrounding my property, and somewhere in the distance, a woodpecker hammered away at breakfast. I'd bought this place 3 years ago specifically to escape the chaos of my law practice in Charlotte, never imagining that a homeowners association could reach its tentacles this far into the wilderness. My name is Keith Lawson, and I've spent the last 15 years specializing in real estate law. I've handled everything from complex commercial transactions to bitter property disputes, and I've made a comfortable living helping people navigate the labyrinth of contracts, easements, and zoning regulations. But standing there with that letter in my hands, I realized I'd made a critical mistake. I'd underestimated the sheer vindictiveness of a bored HOA president with too much time and too little oversight. I tore open the envelope and scanned the contents. The words jumped out at me like a series of punches: violation of covenants, failure to comply with architectural standards, forced sale proceedings, and finally, the knockout blow: buyer has been identified and approved by the board. My cabin wasn't some ramshackle disaster. It was a beautiful 2-story structure with cedar siding, a stone chimney, and a wraparound porch that offered views of the Blue Ridge Mountains. I'd spent countless weekends here, grilling steaks, reading case law by the fireplace, and occasionally hosting friends who needed a break from city life. The property was immaculate, the landscaping pristine, and every single improvement I'd made had been documented and submitted to the HOA for approval. Or so I thought. According to the letter, I'd violated Section 7.3 of the covenants by installing a non-approved outdoor structure without written permission. They were referring to the pergola I'd built last summer, a simple wooden frame covered in climbing roses that my girlfriend at the time had insisted would be romantic. I'd submitted the plans in May, received verbal approval from Susan herself, and completed the construction in June. Now, 9 months later, she was claiming I'd never gotten proper authorization. The letter went on to detail a series of other alleged violations. My mailbox was painted the wrong shade of black, my exterior light fixtures weren't on the approved vendor list, and apparently I'd been parking my truck in the driveway instead of the garage, which violated some obscure clause about visual harmony. The whole thing was absurd, a transparent fabrication designed to justify what came next: the forced sale. I read that section twice, my lawyer brain automatically flagging the legal issues while my human brain simmered with rage. According to Susan's letter, the HOA board had voted unanimously to exercise their right under Section 12.5 of the covenants to force the sale of my property due to persistent and egregious violations. The buyer, pre-approved by the board, was willing to purchase the cabin for $400,000. I'd paid $650,000 for the place. The letter was signed with Susan's elaborate signature, complete with a heart over the I in Patterson and countersigned by the other board members. I recognized 2 of the names: Margaret Chen, who lived in the largest house in the development and hosted wine parties I'd never been invited to, and Robert Dunmore, a retired banker who spent his days riding around the neighborhood in a golf cart looking for violations. I pulled out my phone and called my assistant, Michelle, at the Charlotte office. She answered on the second ring. "Keith, aren't you supposed to be on vacation?" "Vacation's over. I need you to pull the complete HOA file for Mountain Vista Estates. Everything. The original covenants, all amendments, board meeting minutes for the last 5 years, and any correspondence we have with the HOA." "What happened?" "Susan Patterson happened. She's trying to force a sale of my cabin." Michelle whistled. "She actually went through with it? I thought she was just threatening." "Wait, what? What threats?" There was a pause. "The letters we forwarded to you last month, 3 of them from the HOA, all about various violations. I sent them to your email." I closed my eyes. I'd been buried in a massive commercial real estate deal in February, barely sleeping, living on coffee and adrenaline. I'd probably skimmed the emails and forgotten about them. "Forward them again. And Michelle, this is priority 1. Clear my schedule for the rest of the week. You've got the Morrison closing on Thursday. Reschedule it. This is personal." I spent the next 3 hours sitting at my dining room table, reviewing documents on my laptop. The picture that emerged was worse than I'd imagined. Susan had been building a case against me for months, documenting every tiny deviation from the HOA's Byzantine rules. She'd hired a professional photographer to take pictures of my mailbox from multiple angles. She'd filed complaints about the excessive noise from my truck, despite the fact that I drove a nearly silent Ford F-150 hybrid. She'd even claimed that my chimney smoke constituted a nuisance under the environmental protection clauses of the covenants. But the real issue became clear when I found the name of the approved buyer buried in an attachment to the forced sale notice: Brandon Holloway. I knew that name. Everyone in North Carolina knew that name. Brandon Holloway was the son of President James Holloway, who'd been elected in 2024. The younger Holloway had made headlines for his real estate investments, his Silicon Valley connections, and his very public lifestyle that included yachts, private jets, and a rotating cast of models and actresses. He was 32, wealthy beyond measure, and apparently interested in my cabin. I did some quick research and discovered that Brandon had been buying up properties throughout the mountain communities around Asheville. He was assembling a portfolio of luxury vacation homes with plans to create an exclusive private club for the ultra-wealthy. My cabin, with its prime location and mountain views, would be a perfect addition to his collection, and Susan Patterson was apparently helping him acquire it at a bargain price. I made another call, this time to Gerald Finch, a lawyer I'd gone to law school with who specialized in HOA disputes. Gerald had made a career out of defending homeowners against overreaching associations, and he'd written 2 books on the subject. "Keith Lawson," Gerald answered warmly. "To what do I owe the pleasure?" "I need your brain for a few minutes. HOA is trying to force a sale of my cabin based on covenant violations." "Mountain Vista Estates? I've heard stories about that place. Susan Patterson, right?" "You know her?" "Only by reputation. She's been president there for 7 years? Place has some of the most restrictive covenants in the state. Let me guess, she's claiming you violated the architectural standards?" "Among other things. Gerald, they've got a buyer lined up, Brandon Holloway." Gerald was quiet for a moment. "The president's son?" "That's the one." "Well, that explains it. Keith, you're not dealing with a typical HOA dispute. This is corruption, plain and simple. Susan's probably getting a kickback from Holloway, or he's promised her something. You need to fight this hard and fast." "What are my options?" "First, check the forced sale provision in your covenants. In North Carolina, those clauses are heavily scrutinized by courts. They have to follow strict procedures, provide adequate notice, and prove that the violations are substantial. From what you're describing, Susan's reaching. Second, document everything, every approval you got, every fee you paid, every interaction with the HOA. Third, file an injunction immediately. Don't wait for them to go through with the sale." "What about the buyer? Can I go after Holloway directly?" "Careful there. You're talking about the president's son. But if you can prove he's colluding with the HOA to defraud you of your property, you might have a case. You'd need solid evidence, though. Emails, recorded conversations, financial records showing payoffs. It's not going to be easy." I thanked Gerald and hung up. My mind was already working through the strategy. I had 3 weeks before the forced sale was scheduled to complete, 3 weeks to dismantle Susan's scheme and protect my property. I spent the rest of the day compiling evidence. I found the email where Susan had verbally approved my pergola plans, though she'd carefully avoided putting the approval in writing. I found receipts showing I'd purchased my light fixtures from a vendor that had been on the approved list when I installed them, only to be removed months later. I found photographs proving my mailbox had been the correct color for 2 years before Susan suddenly decided it violated the standards. The next morning, I drove into Asheville and filed an emergency motion for a temporary restraining order in Buncombe County Superior Court. I asked the court to halt the forced sale proceedings and require the HOA to show cause why the sale should be allowed to proceed. I attached 60 pages of exhibits documenting Susan's pattern of selective enforcement and procedural violations. The hearing was scheduled for Friday, 2 days away. I used those 2 days to do something I normally avoided. I got political. I called every contact I had in Asheville, every lawyer, real estate agent, and local official who might have information about Brandon Holloway's property acquisitions. What I discovered was disturbing. Holloway had purchased 7 properties in the mountain communities over the past 18 months, and in every case, the sellers had accepted prices well below market value. In 3 of those cases, the sellers had been facing HOA violations and forced sale proceedings. The pattern was unmistakable. Holloway had found a way to game the system, using HOAs as a tool to pressure owners into selling at discount prices, but proving it was another matter entirely. Friday morning arrived cold and bright. I put on my best courtroom suit, a charcoal gray Tom Ford that had cost me a month's salary when I was a junior associate, and drove to the courthouse. I arrived early and sat in my truck, reviewing my notes and mentally preparing for the arguments I'd need to make. At 9 o'clock, I walked into the courthouse and made my way to Judge Patricia Reynolds' courtroom. Judge Reynolds had a reputation as a no-nonsense jurist who didn't tolerate procedural games. I was counting on that. Susan Patterson was already there, sitting at the defendant's table with a lawyer I didn't recognize. He was young, maybe 30, wearing an expensive suit and an expression of supreme confidence. Susan looked exactly as I'd expected, perfectly coiffed blonde hair, designer clothes that screamed, "I have money and want everyone to know it," and a smile that didn't reach her eyes. The lawyer stood as I approached. "Keith Lawson, I'm Todd Pemberton, representing the Mountain Vista Estates HOA. I was hoping we could reach a settlement before bothering the judge." "What kind of settlement?" "My client is willing to drop the forced sale proceedings if you agree to remove the non-compliant structures from your property and pay a fine of $50,000 for the violations." I almost laughed. "That's not a settlement, that's extortion. Tell your client I'll see her in court." Todd's confident expression flickered. "Mr. Lawson, I should warn you that we have substantial documentation of your violations. The covenants are very clear, and the board has broad discretion in enforcement matters. You're not going to win this. We'll let the judge decide that." Judge Reynolds took the bench at 9:15, and we proceeded with arguments. I went first, laying out the timeline of events and highlighting the procedural violations I'd identified. I emphasized that Susan had given verbal approval for the pergola, that the other alleged violations were trivial at best, and that the forced sale provision was being used as a weapon rather than a legitimate enforcement tool. Todd countered with a stack of photographs and documents showing my alleged violations. He argued that the covenants gave the HOA board absolute discretion in enforcement matters, and that my failure to comply with written approval requirements justified the forced sale. Judge Reynolds listened patiently, occasionally asking questions. When we'd both finished, she leaned back in her chair and studied the documents in front of her. "Mr. Pemberton," she said finally, "I'm troubled by several aspects of this case. First, the timeline suggests that the HOA president verbally approved Mr. Lawson's pergola, but failed to provide written confirmation. That raises questions about whether Mr. Lawson had reason to believe he was in compliance. Second, the other violations you've cited appear to be minor and technical in nature. A mailbox shade that's slightly off, light fixtures from a vendor that was removed from the approved list after installation. These don't rise to the level that would justify a forced sale. Third, and most importantly, the forced sale provision in your covenants requires the HOA to follow a specific progressive discipline process before resorting to such a drastic measure. From what I can see in the record, that process wasn't followed here." Todd stood quickly. "Your Honor, with respect, the covenants give the board discretion to accelerate enforcement in cases of egregious violations. And I'm telling you, Mr. Pemberton, that I don't see egregious violations here. I see an HOA president with an axe to grind. Mr. Lawson, your motion for a temporary restraining order is granted. The forced sale proceedings are hereby stayed, pending a full hearing on the merits. We'll schedule that for," she checked her calendar, "4 weeks from today. In the meantime, the HOA is prohibited from taking any enforcement action against Mr. Lawson's property." I felt a surge of relief, but I knew this was just the first battle. Susan would regroup and come back harder. As I left the courtroom, I noticed someone sitting in the gallery who hadn't been there before. He was young, athletic-looking, wearing jeans and a polo shirt that probably cost more than most people's monthly mortgage payment. I recognized him immediately from the photos I'd seen online. Brandon Holloway. He stood as I passed and extended his hand. "Mr. Lawson? I'm Brandon Holloway. I was hoping we could talk." I ignored his hand. "We have nothing to talk about." "I think we do. Look, I understand you're upset about the situation, but this doesn't have to be adversarial. I'm willing to pay fair market value for your cabin. $650,000, the full amount you paid for it." "Not interested." "700,000. "Still not interested." Brandon's friendly expression hardened slightly. "Mr. Lawson, I'm trying to be reasonable here. The HOA has legitimate concerns about your property violations, and I'm offering you a way out that doesn't involve years of litigation. You're a smart man. Take the deal." "Let me be very clear, Mr. Holloway. My cabin isn't for sale, not to you, not to anyone. And if I find out that you've been colluding with Susan Patterson to manufacture these violations, I'm going to bury you in litigation." "I don't care who your father is." Brandon's face flushed. "That sounds like a threat." "It's a promise. Stay away from my property." I walked out of the courthouse, my heart pounding. I'd just threatened the president's son, which was probably not my smartest move. But I was angry, and I wasn't going to let some entitled rich kid steal my cabin. Over the next 2 weeks, things escalated quickly. Susan filed a motion to dissolve the restraining order, arguing that I was using my legal expertise to intimidate the HOA. Todd submitted additional evidence of violations, including reports from neighbors claiming that my cabin generated excessive traffic and noise. The reports were obviously fabricated. I only visited the cabin on weekends, and I rarely had more than 1 or 2 guests at a time. I responded with my own motion, requesting that the court order the HOA to produce all communications between Susan Patterson and Brandon Holloway. If I could prove they were working together, I could potentially get the forced sale dismissed and even pursue criminal charges for fraud. The judge granted my motion, and 2 weeks later, I received a box of documents from the HOA's lawyer. Most of it was routine correspondence, but buried in the middle of the stack, I found what I was looking for: an email thread between Susan and Brandon discussing my property. The first email was from Brandon, dated 4 months earlier. "Susan, following up on our conversation about the properties in Mountain Vista, the Lawson cabin would be perfect for my project. Can you make it happen?" Susan's response: "Leave it to me. I'll find a way to bring him into compliance or force a sale. Give me a few months to build the case." There were a dozen more emails, laying out their plan in explicit detail. Susan would document violations, manufacture complaints from neighbors, and use the forced sale provision to pressure me into selling. Brandon would purchase the property at below market value, with the understanding that Susan would receive a consulting fee of $50,000 once the sale closed. It was exactly the evidence I needed. I immediately filed an amended complaint, adding claims for fraud, conspiracy, and violation of the North Carolina Unfair and Deceptive Trade Practices Act. I also sent copies of the emails to the local district attorney's office, suggesting they might want to investigate potential criminal conduct. The response was swift and dramatic. Todd Pemberton withdrew as the HOA's counsel, citing ethical concerns. Susan resigned as HOA president, though she claimed it was for personal reasons unrelated to the litigation. And Brandon Holloway's lawyer sent me a letter offering to settle all claims for $1 million, plus my attorney's fees and costs. I turned it down. This wasn't about money anymore. It was about principle. Susan and Brandon had tried to steal my property using the legal system as their weapon. They'd fabricated violations, corrupted the HOA process, and conspired to defraud me of hundreds of thousands of dollars in equity. I wanted justice, not a paycheck. The full hearing took place 6 weeks after my initial restraining order was granted. By that time, the story had leaked to the press and the courthouse was packed with reporters. The headline in the Asheville Citizen-Times read, "President's son accused of HOA corruption scheme." Brandon didn't attend the hearing, but his lawyer was there, a high-powered attorney named Marcus Delgado who'd flown in from Washington specifically for the case. Marcus was smooth, polished, and utterly ruthless. He argued that the emails had been taken out of context, that Brandon had simply expressed interest in purchasing my cabin if it ever became available, and that Susan's actions were her own and didn't reflect any conspiracy with his client. But I had more than just the emails. I'd subpoenaed the HOA's bank records and discovered that Susan had received a wire transfer of $25,000 from one of Brandon's shell companies 2 days after I'd been served with the forced sale notice. I'd also found evidence that Brandon had used the same scheme with other properties in the area, working with compliant HOA board members to manufacture violations and force sales. Judge Reynolds wasn't buying Marcus's arguments. After 2 days of testimony and argument, she issued a scathing ruling from the bench. This court finds that the forced sale proceedings were initiated in bad faith and for an improper purpose, she said, her voice sharp with anger. The evidence clearly shows that Ms. Patterson and Mr. Holloway conspired to deprive Mr. Lawson of his property through fraudulent means. The forced sale is hereby dismissed with prejudice. Furthermore, the court finds that the HOA's actions constitute a violation of the North Carolina Unfair and Deceptive Trade Practices Act, and Mr. Lawson is entitled to treble damages for the harm he has suffered. She ordered the HOA to pay me $300,000 in damages, plus attorney's fees and costs. She also issued an order preventing the HOA from taking any enforcement action against my property for a period of 5 years, absent clear and egregious violations of the covenants. But she couldn't do anything about Brandon Holloway directly. He wasn't a party to the HOA enforcement action, and his involvement, while clearly improper, hadn't technically violated any laws that gave the civil court jurisdiction over him. That's where the district attorney came in. 3 days after Judge Reynolds issued her ruling, I received a call from Assistant District Attorney Linda Morrison. She'd been reviewing the evidence I'd submitted and wanted to discuss potential criminal charges. Mr. Lawson, based on what I've seen, we have enough to charge both Ms. Patterson and potentially Mr. Holloway with conspiracy to commit fraud and extortion. The problem is, Holloway's got resources we can't match. His father's the president, and he's got a team of lawyers who'll fight us every step of the way. I need to know that you're willing to testify and see this through to the end. I'm willing, I said without hesitation. Good, because this is going to get ugly. She wasn't exaggerating. The day after the district attorney's office announced they were pursuing criminal charges, I received a visit from 2 men in dark suits who identified themselves as Secret Service agents. They asked me questions about my interactions with Brandon Holloway, whether I'd made any threats against him, and whether I had any history of violence. It was clear what was happening. The Holloway family was trying to intimidate me, using the power of the presidency to make me back off. But I'd dealt with bullies before, and I wasn't going to be scared away. The criminal investigation took months. Linda Morrison was thorough, subpoenaing records from Brandon's companies, interviewing witnesses, and building a case that even the best defense lawyers would struggle to defeat. She discovered that Brandon had used the same scheme in 4 other states, working with corrupt HOA board members to acquire properties at below-market prices. The total value of the fraud was estimated at over $10 million. Susan Patterson was arrested in August on charges of conspiracy, fraud, and extortion. She immediately agreed to cooperate with prosecutors in exchange for a reduced sentence, providing detailed testimony about her dealings with Brandon and his representatives. Brandon himself was arrested in September, a scene that played out on national television. The president issued a statement saying he was deeply disappointed in his son's actions, but wouldn't interfere with the legal process. Political opponents seized on the scandal, using it as evidence of the Holloway family's corruption. The whole thing became a media circus, with talking heads on cable news debating whether Brandon should receive special treatment because of his father's position. I tried to stay out of the spotlight, but it wasn't easy. Reporters camped outside my Charlotte office in my cabin, hoping for interviews. I declined them all, focusing instead on my testimony preparation and my regular legal work, which had been neglected for months. The trial began in February of the following year. It lasted 3 weeks and featured testimony from dozens of witnesses, including homeowners who'd been victimized by Brandon's scheme, HOA board members who'd been approached with similar deals, and financial experts who walked the jury through the money trail connecting Brandon to the various frauds. I testified for 2 days, walking the jury through my experience with Susan and the Mountain Vista Estates HOA. I explained how I'd discovered the conspiracy, showed them the emails and financial records, and described the impact the ordeal had on my life. The defense tried to portray me as a disgruntled homeowner with a grudge, but the documentary evidence was too strong. Susan testified for the prosecution, confirming everything I'd said and adding details about how Brandon's representatives had recruited her into the scheme. She broke down crying on the stand, saying she'd been seduced by the money and the promise of becoming part of an exclusive social circle. It was a convincing performance, though I had no sympathy for her. Brandon didn't testify. His lawyers advised him to invoke his Fifth Amendment rights, which was probably smart but looked terrible to the jury. The verdict came back on a Thursday afternoon, guilty on all counts. Brandon was convicted of conspiracy, fraud, extortion, and multiple violations of federal wire fraud statutes. He faced up to 20 years in prison. Susan received a sentence of 3 years, most of which was suspended in light of her cooperation. She was also ordered to pay restitution to the homeowners who'd been victimized by the scheme. Brandon's sentencing hearing was another media spectacle. The president didn't attend, sending a written statement asking the court for leniency, but acknowledging his son's crimes. Brandon's lawyers argued that he'd been influenced by the competitive world of real estate development and hadn't fully understood the legal implications of his actions. The prosecution countered that he'd orchestrated a sophisticated fraud that had harmed dozens of families. The judge sentenced him to 8 years in federal prison, followed by 3 years of supervised release. He was also ordered to pay $5 million in restitution to the victims of his scheme. I was in the courtroom when the sentence was handed down. Brandon's face was pale, his confident expression finally cracked. As the marshals led him away, he looked at me, and I saw something in his eyes that might have been respect or might have been hatred. I didn't care either way. The civil case against the Mountain Vista Estates HOA was settled shortly after the criminal trial concluded. The HOA's insurance company, facing massive liability for the board's actions, agreed to pay me a total of $800,000 in damages and attorney's fees. They also agreed to completely reform the HOA's governance structure, implementing new rules to prevent future abuses. The other board members who'd gone along with Susan's scheme resigned. New elections were held, and a group of more reasonable homeowners took control. One of the first things they did was pass a resolution apologizing to me for the HOA's actions and welcoming me back as a member of the community. I attended the meeting where the apology was issued. It was held in the community clubhouse, a rustic building with exposed beams and a stone fireplace. About 40 homeowners showed up, including several who'd supported Susan's enforcement actions against me. The new president, a retired teacher named Dorothy Kramer, read the apology from a prepared statement. Mr. Lawson, on behalf of the Mountain Vista Estates Homeowners Association, I want to offer our sincere apologies for the actions taken against you by the previous board. Those actions were improper, illegal, and contrary to the values of our community. We hope you'll accept this apology and continue to be a valued member of our neighborhood. I stood and addressed the crowd. I appreciate the apology. What happened over the past year was difficult and expensive, but it exposed serious problems in how this HOA was being run. I hope the new board will learn from those mistakes and govern with transparency and fairness. As for me, I plan to keep my cabin and continue enjoying the mountains, but I'll be watching to make sure we never go back to the old ways. There was applause, and several people came up to shake my hand afterward. A few even apologized personally for believing Susan's lies about me. It felt like closure, or at least the beginning of it. I spent the next several months putting my life back together. The case had consumed nearly a year of my time and cost me hundreds of thousands in lost income and legal expenses, even with the settlements. But I'd protected my property and exposed a significant fraud. More importantly, I'd sent a message that HOAs couldn't abuse their power without consequences. The cabin became a refuge again. I spent weekends there, reading, hiking, and occasionally hosting friends who wanted to hear the story firsthand. The pergola that had started the whole mess was still standing, covered in roses that bloomed beautifully that spring. I'd never take it down, not after everything it represented. I also started taking on more HOA cases in my practice. Word spread about what I'd done, and homeowners throughout North Carolina started reaching out for help with their own disputes. Some were legitimate enforcement actions that the homeowners simply didn't like, but others showed clear patterns of abuse and selective enforcement. I took on the cases where I believed the homeowners were truly being victimized, and I won more often than not. Gerald Finch invited me to co-author an article about HOA reform for the North Carolina Bar Journal. We wrote about the need for stronger oversight of HOA boards, better training for board members, and clearer legal standards for when forced sales could be used. The article was published in the fall and sparked a broader conversation about HOA governance across the state. The political fallout from Brandon's conviction continued for months. President Holloway's approval ratings dropped, and several members of Congress called for investigations into whether he'd tried to interfere with the prosecution. A special counsel was appointed to look into the matter, though ultimately no evidence of presidential interference was found. The president finished his term but announced he wouldn't seek re-election, citing the toll the scandal had taken on his family. As for Brandon, he served his time at a federal prison camp in Pennsylvania. I heard through the grapevine that he'd become something of a model prisoner, teaching other inmates about real estate investing and working in the prison library. Whether he'd actually learned anything from his experience or was just playing the game for early release, I couldn't say. Susan Patterson left North Carolina entirely. I heard she moved to Florida, where she reportedly got a job as a property manager for a condo complex. I hoped she'd learned her lesson, but I doubted it. People like Susan rarely changed. 2 years after the whole ordeal began, I was sitting on my cabin porch on a Saturday morning, drinking coffee and watching the sunrise paint the mountains in shades of gold and purple. The air was crisp and clean, carrying the scent of pine and earth. A deer wandered across my lawn, pausing to look at me before continuing into the woods. My phone buzzed with an email from Dorothy Kramer, the HOA president. She was writing to let me know that the board had voted to eliminate the forced sale provision from the community covenants entirely. Going forward, the HOA would have to pursue traditional legal remedies for covenant violations, just like any other plaintiff. The change would need to be approved by a vote of all homeowners, but Dorothy was confident it would pass. I replied, thanking her for the update and offering to help draft the amendment language. It felt right, using my expertise to prevent others from going through what I'd experienced. Later that morning, I drove into Asheville for breakfast at a diner I'd discovered during the investigation. The waitress, a woman named Betty, who'd served me countless times over the past 2 years, greeted me with a smile and a pot of coffee. "You look happy," she said, filling my cup. "I am," I replied. "Things are finally back to normal. I read about that case in the paper. You really took on the president's son." "I really did. Good for you. Most people would have been too scared." I thought about that as I ate my eggs and bacon. Fear would have been the rational response. Brandon Holloway had resources I could never match, connections that reached the highest levels of government, and every advantage wealth and privilege could provide. Fighting him should have been suicide. But I'd had something he didn't. I was right. The law, for all its flaws and complexities, still meant something. Justice still mattered. And when you knew the system well enough, you could make it work even against the most powerful opponents. That realization had changed how I approached my practice. I started taking more cases pro bono, helping homeowners who couldn't afford lawyers but were being crushed by HOA fines and foreclosure actions. I worked with legal aid organizations to create clinics where people could get advice about covenant disputes. I even testified before a state legislative committee about the need for HOA reform, helping to draft new statutes that gave homeowners better protections. The work was rewarding in ways that my high-dollar commercial deals had never been. I was using my skills to help people who really needed it and making a tangible difference in their lives. On the professional front, the publicity from the case had actually helped my career. I'd worried that going after the president's son might make me radioactive to potential clients, but the opposite happened. Companies and individuals saw that I was willing to fight, regardless of who the opponent was. My client roster grew, and I was able to be more selective about the cases I took on. I hired 2 associate attorneys to help handle the increased workload, both young lawyers who were passionate about property rights and consumer protection. I gave them real responsibility and mentored them the way I wished I'd been mentored when I was starting out. It felt good to build something larger than just a practice. One evening in late spring, about 3 years after the initial confrontation with Susan Patterson, I was at my cabin with my new girlfriend, Grace Ellis. Grace was a landscape architect I'd met through mutual friends, a warm and funny woman who shared my love of the mountains. She'd helped me redesign the gardens around the cabin, creating spaces that were both beautiful and natural, blending seamlessly with the surrounding forest. We were grilling steaks on the porch, watching the sun set behind the mountains, when Grace asked me something that had clearly been on her mind. "Do you ever regret buying this place? I mean, given everything that happened?" I thought about it for a moment, watching the smoke rise from the grill. No, this cabin represents something important to me. It's a place where I can be myself, away from the office and the cases and all the noise. Susan and Brandon tried to take that away, and fighting back was the right choice. If I'd let them win, I would have regretted it for the rest of my life. But it cost you so much: time, money, stress. True, but I also learned a lot about myself. I learned that I'm not willing to back down when I know I'm right. I learned that the legal system can work if you know how to use it. And I learned that standing up to bullies, even powerful ones, is worth whatever it costs. Grace smiled and leaned over to kiss me. "That's one of the things I love about you. You're principled, even when it's hard." We ate dinner as the stars came out, talking about plans for the future. Grace wanted to expand the gardens, maybe add a greenhouse where we could grow vegetables year-round. I wanted to add a deck off the master bedroom with views of the valley below. They were simple dreams, the kind of plans that homeowners make all the time. The difference was, I now knew exactly how to navigate the HOA approval process. I'd submit detailed plans, get everything in writing, and document every step. I'd learned my lesson about trusting verbal approvals. The next morning, I was up early, drinking coffee on the porch and reviewing a case file on my laptop. It was a complex boundary dispute involving a property line that had been incorrectly surveyed 60 years earlier. The kind of case that required deep historical research and creative legal arguments. My phone rang. It was Dorothy Kramer. "Keith, I hope I'm not calling too early." "Not at all. What's up?" "I wanted to give you a heads up. We're having a special meeting tomorrow night to vote on the covenant amendments, including removing the forced sale provision. I'd love it if you could attend and answer any questions people might have." "I'll be there." The meeting was held in the same clubhouse where I'd received the apology 3 years earlier. This time, nearly 70 homeowners showed up, filling every seat and lining the walls. There was a buzz of conversation as people discussed the proposed changes. Dorothy called the meeting to order and explained the amendments. In addition to removing the forced sale provision, the new covenants would require the board to follow progressive discipline for violations, provide homeowners with detailed written notice of any alleged problems, and allow for an appeal process before any major enforcement action could be taken. Several people raised their hands with questions. One homeowner, a man I didn't know, asked why the forced sale provision was being removed. "Isn't that an important tool for dealing with properties that are really out of control?" he asked. I stood and addressed the question. "In theory, yes, but in practice, forced sale provisions are easily abused. What happened to me is an extreme example, but even in less dramatic cases, the threat of losing your home creates an imbalanced power dynamic. The HOA can essentially hold your property hostage over minor violations. The better approach is to use traditional legal remedies, fines, liens, and if necessary, lawsuits. Those processes have built-in protections for homeowners and prevent the kind of abuse we saw with the previous board. Another homeowner asked about the costs of enforcement without the forced sale option. "Won't this make it harder to deal with problem properties?" "It will make it slightly more time-consuming," I admitted, "but it will also force the board to think carefully about which violations are really worth pursuing." In my experience, most HOA disputes can be resolved through conversation and compromise. The legal tools should be a last resort, not a first option. The questions continued for nearly an hour, covering everything from specific language in the amendments to concerns about property values. But by the end, Most people seemed convinced that the changes were necessary. Dorothy called for a vote. The amendments passed with 87% approval. After the meeting, several homeowners came up to thank me for my role in reforming the HOA. One woman, an elderly widow who lived alone, told me that she'd been terrified of the previous board and had lived in constant fear of receiving violation notices. "I can finally relax and enjoy my home," she said, tears in her eyes. "Thank you for fighting back." Those words stayed with me as I drove home that night. The fight with Susan and Brandon hadn't just been about my property. It had been about standing up for everyone who'd ever felt powerless against an abusive HOA. By refusing to back down, I'd created change that would protect others for years to come. The following months brought a sense of peace I hadn't felt in years. My practice thrived, my relationship with Grace deepened, and my cabin remained the sanctuary I'd always intended it to be. I still received occasional inquiries from reporters about the case, especially when Brandon was released from prison after serving 5 years. But I declined all interview requests, preferring to let the court records speak for themselves. I heard that Brandon had moved to California and was working in tech, supposedly developing an app for property management. The irony wasn't lost on me. Susan Patterson faded into obscurity. The last I heard, she'd been fired from her property management job in Florida after homeowners complained about her aggressive enforcement tactics. Some people never learned. On a Saturday morning in June, 5 years after receiving that initial certified letter, I was working in my garden when a car pulled up to my cabin. A young man in his late 20s got out, looking nervous. "Mr. Lawson, I'm David Richardson. I live over in Mountain Creek Estates, about 20 miles from here. I was hoping I could talk to you about an HOA problem I'm having." I invited him up to the porch and listened as he explained his situation. His HOA was threatening to foreclose on his property over unpaid fines related to the color of his house, which the board claimed violated the architectural standards. David had purchased the house 3 years earlier, and the color had been the same since before he bought it. The previous owner had never received any complaints. It was a familiar story. Another HOA board drunk on power, another homeowner being victimized by selective enforcement. "What do you want to do about it?" I asked. Fight back. I can't afford to lose my house, but I also can't afford an expensive lawyer. I was hoping you might be willing to help, or at least give me some advice." I looked at this young man, seeing in him the same determination I'd felt when Susan Patterson had tried to force me out. He deserved a chance to defend himself. "Tell you what," I said, "come by my office on Monday. Bring all your paperwork, everything the HOA has sent you. We'll review it together and figure out your options. First consultation is free." David's face lit up with relief. "Thank you, Mr. Lawson. I really appreciate it." After he left, I sat on the porch and thought about how much my life had changed since that day I'd received Susan's letter. I'd gone from being just another real estate attorney to someone who'd taken on the president's son and won. I'd exposed corruption, reformed an HOA, and inspired other homeowners to stand up for their rights. But more than that, I'd found my purpose. I wasn't just practicing law anymore. I was fighting for justice, one homeowner at a time. Grace came out onto the porch, carrying 2 glasses of lemonade. She'd spent the morning working in the flower beds and had dirt on her knees and a satisfied smile on her face. "Who is that?" she asked, handing me a glass. "Another homeowner with an HOA problem. Are you going to help him?" "Of course." She sat down beside me and took my hand. "You know what I love about you? You could be making millions doing corporate work, but instead, you're spending your time helping people fight HOA disputes. That takes real character. Someone has to do it. HOAs have too much power, and homeowners need advocates who understand the system." We sat in comfortable silence, watching the mountains and enjoying the perfect summer day. My phone buzzed with emails, undoubtedly other homeowners reaching out for help. There would always be more cases, more fights, more opportunities to stand up against injustice. But right then, in that moment, I was exactly where I needed to be. In my cabin, on my mountain, surrounded by the beauty I'd fought so hard to protect. Susan Patterson and Brandon Holloway had tried to take this from me. They'd used their power and influence to manipulate the system, confident that I'd back down or accept their terms. They'd underestimated me, and it had cost them everything. I'd learned valuable lessons from that experience. I'd learned that wealth and privilege don't guarantee victory. I'd learned that documentation and preparation can overcome even the most powerful opponents. And I'd learned that sometimes the right thing to do is also the hard thing to do. Those lessons had made me a better lawyer and a better person. They'd shaped my practice and my priorities, guiding me toward work that mattered rather than work that simply paid well. As the sun climbed higher in the sky, Grace and I talked about plans for the rest of the weekend. We'd go hiking in the afternoon, have dinner at our favorite restaurant in Asheville, maybe catch a movie. Simple pleasures, the kind that made life worth living. I thought about all the homeowners I'd helped over the years, all the people who'd been able to keep their homes because I'd fought for them. That was my legacy, not the big commercial deals or the high-profile clients. It was the individual families who'd been saved from foreclosure, the retirees who could stay in their homes, the young couples who'd stood up to abusive HOA boards. My phone rang again. Another potential client. Another person who needed help navigating the complex world of homeowners associations and property law. I answered it, ready to listen, ready to help, ready to fight if necessary. Because that's what I did now. I was Keith Lawson, the real estate attorney who'd taken on the president's son and won. And I wasn't done fighting yet. Not by a long shot. The story of my battle with Susan Patterson and Brandon Holloway had become something of a legend in real estate law circles. I'd been invited to speak at conferences, written articles for legal journals, and even been approached about writing a book. I'd declined the book deal, feeling that some experiences were too personal to commercialize, but I was happy to share the lessons I'd learned with other lawyers and homeowners. The more people understood their rights and how to defend them, the less power abusive HOAs would have. That evening, as Grace and I sat by the fire pit behind the cabin, roasting marshmallows and watching the stars come out, I felt a profound sense of contentment. The journey from that threatening letter to this peaceful moment had been long and difficult, but it had been worth every minute. My cabin stood strong and beautiful, a testament to the principle that you don't have to surrender to bullies, no matter how powerful they are. The mountains stretched out before me, vast and eternal, reminding me that there were things bigger than property disputes and legal battles. But those battles mattered too. They mattered to the people whose homes and dreams were on the line. They mattered to the principle that the law should protect the weak, not empower the strong. And they mattered to me, because I'd discovered that standing up for what was right gave my life meaning. Grace leaned against me, and I wrapped my arm around her shoulders. Tomorrow would bring new challenges, new cases, new fights. But tonight, I was home, in every sense of the word. And no one, not Susan Patterson, not Brandon Holloway, not anyone, could take that away from me ever again.